Building upon the previous discussion of a licensee's obligation to disclose all known material facts, it is essential to understand that Arizona law extends disclosure duties not only to clients, but to every party involved in a real estate transaction. This includes buyers, sellers, tenants, landlords, and even cooperating brokers. The purpose of this legal and ethical standard is to ensure fairness, honesty, and transparency across all sides of the transaction, preventing misrepresentation and protecting the public interest. Under Commissioner's Rule R4-28-11001A, a real estate licensee must deal fairly and honestly with all parties to a transaction, regardless of who they represent. This rule forms the foundation of Arizona's professional conduct standards. While fiduciary duties, such as loyalty and obedience, apply specifically to clients, duties of fair dealing, truthful representation, and full disclosure of material facts apply universally. Even when the licensee's primary obligation is to their client, they are still legally required to ensure that no party to the transaction is misled or deceived. For example, a listing agent representing a seller must disclose all known material facts about the property to potential buyers and their agents. These facts may include a roof in poor condition, an unpermitted addition, known foundation issues, or nearby nuisances that could affect property value. Likewise, a buyer's agent has a duty to disclose material information that might affect the seller's decision-making, such as a buyer's inability to secure financing or a withdrawal of loan approval. If it impacts the completion of the transaction, these actions are not just ethical. They are legally mandated under ARS Section 32-2153A3. Consider a practical example. A licensee represents a buyer who submits an offer on a property, but later learns that the buyer's financing has fallen through. If the licensee continues to negotiate with the seller or fails to disclose that the buyer can no longer perform, they have breached their duty to act honestly with all parties. This could lead to contract disputes and possible disciplinary action by the Arizona Department of Real Estate ADRE for misrepresentation or omission of material facts. Arizona courts have consistently reinforced that licensees cannot remain silent about facts that they know, or should reasonably know, to be material to the transaction. In Lombardo v. Albu, 1996, the Arizona Court of Appeals held that a real estate agent's duty of honesty extends to all participants, even those not represented by the agent. The court emphasized that a licensee must not misrepresent or conceal facts when those facts are known to be significant to the transaction. Similarly, Hill v. Jones, 1986, underscored that non-disclosure of known defects constitutes fraud when those defects materially affect the value or desirability of the property. The duty of disclosure owed to all parties includes not only property-related issues, but also transactional matters that could influence a party's decision to proceed. For instance, if a licensee learns that a property is subject to a pending foreclosure, that information must be disclosed to any prospective buyer. Likewise, if the licensee becomes aware that another offer has been accepted or that the seller is under bankruptcy proceedings, such information is material and must be shared promptly with all relevant parties. Additionally, a licensee must not exaggerate or misrepresent features of a property to attract buyers or tenants. For example, advertising a lot as ready to build when the property lacks access to utilities or has zoning restrictions would violate both R4-28-1101A and ARS Section 44-1522, which prohibits deceptive practices under the Arizona Consumer Fraud Act. The duty to disclose requires accuracy and clarity at every stage of the transaction, from marketing materials to final negotiations. The scope of disclosure also extends to defects or issues discovered during inspections. Suppose a home inspection reveals the presence of mold or structural deficiencies. Even if the seller chooses not to address these issues, the licensee must ensure that the buyer is informed of the findings. The obligation to disclose is continuous and cannot be satisfied by a one-time statement or assumption that the other party already knows. ADRE disciplinary cases frequently involve licensees who fail to update or verify their disclosures when new facts emerge during escrow. Another critical component of this duty involves the use of standardized forms such as the Seller's Property Disclosure Statement, SPDS, and the Residential Seller Advisory provided by the Arizona Association of REALTORS. These documents are designed to ensure that sellers disclose all known conditions of the property. While the seller is responsible for completing these forms, the licensee has an independent duty to review them for completeness and to correct any known inaccuracies. For instance, if the seller claims the home has no roof leaks, but the agent knows repairs were made for recurring leaks, the agent must correct that misinformation before providing it to buyers. Failure to fulfill disclosure duties owed to all parties can have serious consequences. Under ARS Section 32-2153, AA3, ADRE may suspend or revoke a license for any licensee who intentionally or negligently misrepresents or conceals material facts. In severe cases involving intentional deceit, civil liability for fraud may also apply, exposing the licensee to damages and attorney's fees. Review summary. Arizona law holds that real estate licensees owe duties of honesty, fairness, and disclosure to all parties in a transaction, not just their clients. Under R4-28-1101A and ARS Section 32-2153A3, a licensee must disclose all known material facts, avoid misleading statements, and correct known inaccuracies. Court cases such as Hill v. Jones and Lombardo v. Albu reaffirm that withholding or concealing material information constitutes misrepresentation. The use of disclosure documents like the SPDS helps ensure compliance, but licensees must also actively verify and supplement information as necessary. Discussion: why must a licensee disclose material facts to all parties, not just their client? Answer: because R4-28-1101A requires fair and honest dealing with all parties to protect the integrity of the transaction and prevent misrepresentation. What happens if a licensee learns new material information after the initial disclosure? Answer: the licensee must promptly update the disclosure to ensure all parties have current and accurate information, maintaining compliance with ARS Section 32-2153A3. If a seller's SPDS form contains incorrect information, what must the licensee do? Answer: the licensee must correct or supplement the information to prevent material misrepresentation, even if the seller completed the form. Closing remarks. Disclosure is the cornerstone of public trust in real estate. A licensee's responsibility does not end with their client. It extends to every individual impacted by the transaction. Acting with honesty, fairness, and diligence ensures compliance with Arizona law and strengthens professional credibility. The most successful agents are not those who conceal or minimize facts, but those who empower their clients and counterparts through transparency and full disclosure.